What I'm going to do, since we're just taking questions and answers today, is I am going to turn the slides off here. So give me just a moment and we'll make Diane and I the focal point of the program here today. She'll be bringing the questions and I'll do my best to provide the answers, and then she'll provide the answers to the really hard ones, right, Diane?
Something like that.
Diane, I'm going to hand the mic over to you. Floor is yours. The question and answer round is open.
Okay, we will start off with Regulation E. Should provisional credit be provided to business accounts? Even though we know it's not required, are you seeing institutions provide it?
I think that last part of the question really is going to be my answer. Regulation E does not apply to non-consumer accounts. So I would not afford them the same privileges, the same protections, the same rights as that Reg E requires you to provide to those consumer accounts. I mean, Diane, you and I were just talking about this morning. I think your words were Reg E's taking over the world, right? It seems there's so much discussion going on Reg E and how banks are just on the short end of the stick most of the time because of the protections. I certainly would not extend them farther than what the regulation and the law requires, which is consumer accounts. Now, that said, sometimes your commercial customers, your non-consumers, are some of your best customers. And so what we need to apply in that space is what I would say is just plain old everyday customer service. Do what you think's right by your best customers, but you would not have to comply with the Reg E requirements.
Okay, moving on to Regulation DD. Our fee schedule discloses a temporary check fee, each one being $1. Our statement shows the total based on the number of temporary checks. Do we need to disclose that? For example, 5 checks were received, or just the total amount charged?
So on the periodic statement, it needs to be able to demonstrate that multiple fees, that dollar amount includes more than one charge. And so there's various ways you can go about that, but you have to be able to describe that it's more than a singular charge. So as long as you're able to do that, you'd be good with the regulation.
Given the definition of an error under section 1005.11 of Regulation E, do we need to document every time someone questions an EFT transaction?
You know, this is a question that actually got submitted through our quick response consultation, I want to say about a month and a half ago. And then we took it to our team meeting. So this is really cool that this came up in the pre-submitted today. We went and researched it and wanted to make sure we had the exact answer. So we've done the research on this one ahead of time. So when it comes to, you know, I'm standing in the teller line and Diane's the teller and I'm like, you know, hey, I saw this on my online banking. Could you give me a little more information? It doesn't look right. Now, does that maybe kind of sound like a dispute or an error? It could be. But if Diane gives me the information and it satisfies me, oh, it looks like the charge was for, you know, whatever. Oh, okay, you're done. As long as I'm satisfied. So there's no follow-up requirement. There's no provisional credit requirement. If I have inquired and you've satisfied me, we're done.
We have an account called Free Checking. We would like to charge for mailed statements if customers don't sign up for e-statements. Can we do this on a free account?
Okay, so the regulation does not specifically prohibit you from doing what you're asking to do. Now, that being said, we live in a different day and age than when some of these regulations were originally written, where they carved out, you're okay to do this, you're not okay to do that. And so I'll go back to the title. The title of this was Free Checking, and now we want to charge for something. That leaves kind of a nasty taste in my mouth as it relates not so much to Reg DD, because you're not going to find anything in Reg D that says do or don't do that. It's the unfair, deceptive, or abusive acts or practices that are getting a lot of attention these days, and it's going to continue to be that way. That has me concerned about saying it's a free checking account, yet we're charging them for periodic statements. I don't like it personally. I wouldn't do it. Nothing's going to prohibit you from doing so, though, by Reg DD. UDAP maybe, and that's a subjective thing.
We know we're required to mail out 30-day maturity notices if a CD has a term over 1 year, but do we have to mail a rate change notice?
So the maturity notice needs to include the interest rate, the APY, and then for the new account, and then disclose if the API or if the rate's unknown, state that it's unknown and when that will be made available.
What are we required to send as far as maturity notices for CD terms under 1 year?
So you could do the full disclosure. So just like you were opening up a brand new CD, or you could provide them the current and new maturity rates, or maturity dates current and new maturity rates, the rate information, and then if there's any change in terms, that would also have to be noted. For those that are not automatically renewing, you wouldn't have to do anything.
Okay, we'll move to some Reg CC questions. If someone deposits a check into their checking account and does not have balances sufficient to cover it, if it were returned unpaid, what are the hold options within Reg CC?
Well, when it comes to Reg CC, I mean, you've got the different hold reasons, and it can get you up to 7 days. So you've got the large deposit, you've got the returned item one, you've got the overdraft. I mean, you're really quite limited. You could refuse to accept the deposit so long as it's not an on us check. You could take it for collection. You could ask them to put it into a savings account. Be careful with some of that. The savings account doesn't have, by regulation, a time period that it says you have to make it available within. Do check state law, though. So you've got some options in that route.
What do you consider to be the best funds availability practices for cashier's checks, considering fraud and forgery, especially when they are drawn on a bank with which we are not familiar?
Well, the first thing I'm going to do is try to reach out and try to get in contact with that bank. Now, the largest banks in the land, a lot of them don't verify funds and will give you very little information. And so if it's a check that's drawn on another company, you might be able to reach out to that company and they may give you some indication as to whether it's a legitimate check or not. The other thing you can do is, I'll go back to the previous answer. You could refuse to accept it for deposit. You could put it through for collection, but that's going to have a fee that's going to be tied to it. You could ask them to put it into a savings account, and then you could delay it beyond what Reg CC is going to allow you to delay the funds for, because Reg CC doesn't apply to savings accounts. I guess I didn't mention that earlier, but do remember there could be state law implications there as well.
Okay, we have a question on Regulation D. Do we need to be keeping track of excess debits for purposes of Regulation D? Is this something we should expect to come up again at some point?
I tell you what, back in 2020, year of the pandemic, right? Never going to forget that. There was a ton of information that came out just after, I want to say March 1st. And one of the things that the Federal Reserve did is they rolled back these Reg D prohibitions on excess debits. But at the same time, they also did some other things. And I don't recall exactly what was off my head, but these two things happened at the same time. And one of them was not meant to be long-term. The excess debit one is meant, they didn't write that to bring it back. Now, never say never, but it's our understanding in reading the rollback of that prohibition that it's not going to be coming back. Now, they could change their mind, but our understanding is the intention is that it's gone.
Moving on to somewhat of a hot topic, what should we be doing now from a compliance standpoint with regards to all the hype and scrutiny regarding overdraft and non-sufficient funds fees from the CFPB and FDIC?
I tell you what, overdrafts are smoking hot. If you were here in a couple of minutes before we started our program today, I mentioned our monthly peer group that we offer, our monthly connection. It's a virtual compliance peer group, and I want to say probably every month since probably December, and I say December because that's when this train really started going down the tracks. We've talked about something related to overdrafts, and it's not just because the CFPB, they started it, but the OCC has chimed in, the FDIC on multiple occasions has chimed in, and from all different angles. Sometimes it's through supervisory highlights, sometimes it's through exams, sometimes it's through publications, newsletters, things like that. So I don't think there's been a month go by where something overdraft related has not been brought up. And so what should you be doing, I think, is to go back to the question, right, Diane? Well,
Yes.
I think you need to make sure that you're aware of what's being said out there. Make sure you're getting summaries. Make sure you're reading the information. If you don't have time to read it yourself, let a company like ours do the heavy lifting. You can get information from us by way of our monthly connection, that compliance peer group. We write a lot of things in our monthly magazine. We do consultation. And if you don't get it from us, get it from someone, because here's the most important part. Somebody needs to do the research for you, and then that message, or you do the research, and then that message or summary needs to get to management and the board at that 10,000 foot level. They need to know what's going on, because here's what's going to happen at the end of the day. What you're making today when it comes to overdraft related income is likely not going to be sustainable long term. It's going to be cut back. And so what's that going to do to your organization? What's the impact? They need to understand the potential there of what might be lurking just down the road or up over the horizon as it relates to overdrafts. And so I think making sure you understand what's being said and the potential impact, and getting that message to management and the board of directors so they're not hit by a bus, if you will, or blinded by this when and say, gosh, I didn't know this was happening. How, we don't want that to happen. No surprises is what we're looking for.
Regulation E requires the opt-in form to include the maximum number of overdraft fees that can be assessed per day, or to state that there is no limit. Does this require any daily overdraft fee limit or the limit of fees on a single item?
It's going to be both of those. So if you have a daily overdraft limit, whether it's by number or dollar amount, that's going to have to be included. And any other overdraft related limitations as well need to be included in that opt-in form.
Do you have any insight to share on Zelle? There appears to be some discussion as to whether or not these disputes fall under Regulation E. And do you have any best practices as banks roll out this product?
So Zelle is a very popular product. Lots of banks are using it. And I think prior to December of 2021, there was kind of this gray area of, well, are they ours? Are they Zelle's? Whose transactions are these? And if there's a dispute or something unauthorized, who has to deal with it? Is it us, the bank, or is it Zelle? But we offer Zelle. It's through our financial institution. Well, the CFPB put out some updated FAQs in December of 2021 and really put this to bed. We were lucky enough to get an audience with the CFPB, and they were able to give us some additional insight on what they were trying to say in those Q&As, because they're not in plain English. They're better than the nothing that we had before. But I can tell you, Diane and I read them, regular, sideways and upside down, trying to make sense of some of them. We had to reach out. And one of the things that was very clear in the conversation, and Diane, correct me if I'm wrong, you're the one that had the audience, is that Zelle transactions are absolutely covered by the financial institution under Reg E. Now, does that mean Zelle is not covered? No, they're covered as well. So you're going, okay, well, there's Zelle's problem and our problem both at the same time? Yes. So what if the customer just goes to Zelle? Well, then Zelle will have to deal with it. What if the customer comes to us? Well, then we have to deal with it. What if they come to both of us? Both of us have to deal with it. Now, should the customer get refunded from both ends? No, but it's both of yours problems, both Zelle and the financial institution.
Okay, back to Reg CC. We continue to have problems with placing holds on checks that have been deposited to customers' accounts. Please go over how to do this properly, and any worksheet and guidelines would be wonderful too.
So delay notices, there's model forms out there. We've had one that we've presented to financial institutions for years. You likely have a forms vendor that's provided one to you. Just make certain, the number one thing is make certain that the hold form, the delay form, is filled out in its entirety. Check all the boxes, give all the information, and then make sure you retain in your documentation any additional details that might be helpful if you go through an audit or an exam in understanding what's really going on. That story, if you will, the details matter, especially when we check boxes like confidential information or information from the paying bank indicates the check may not be paid. What is that other information? It doesn't need to be disclosed to the customer, but you need it in your possession so that examiner, that auditor, can review it in your examination.
Is the Check 21 disclosure required with the opening of deposit accounts? And if so, which accounts would this be a requirement for?
Okay, so it's triggered by the opening of accounts, but not every account needs to get it. So here's the quick and easy thing. If your customers will not be allowed to get their actual checks back, so I've got my checkbook in my back pocket and I write you out a check and it's going to go through the system and I'm going to get that exact check back. Okay, I don't know the last time I was talking or a part of a review with a bank that actually allowed their customer to get the actual handwritten checks back. So if your customers are not allowed to get their actual checks back, then the Check 21 disclosure is not something that needs to be provided. But if you're still allowing them to get their actual checks back, then the Check 21 disclosure needs to be provided, because that's where the substitute check comes into play, when they don't get the actual check and they get the substitute in lieu of that.
Can a sole proprietor have a debit card in their personal name?
I don't know of any reason why they couldn't. Yeah, they could. I don't know what else it would be.
On March 9th, we had a customer report unauthorized transactions through Venmo, PayPal, Cash App, and Facebook Pay. beginning back on December 14th and first appearing on the January 2022 statement. What is our responsibility? Do we go 60 days from the date the first statement cut in January or the December transaction date?
So I want to go back to the beginning of the question and clarify something and just make sure everybody gets this. So I'm the customer and I'm now coming to you and saying, hey, I noticed that there's been these unauthorized transfers. You mentioned several different varieties, that there was Venmo, PayPal, Cash App, right? Several. Did I hear that correctly?
Correct.
Okay, so that's
Yes.
important, I think. So just set that aside for a moment. The general rule in Reg E is that the financial institution's liability is going to be statement plus 60. What's that mean? The statement on which the error first occurs plus the next 60 days. And so you've got 3 months worth of liability that's tied to the financial institution. The regulations worded such that beyond that time frame, it's the consumer's liability. And so the whole idea behind this is it encourages the person, the consumer, your customer, if they do see something, to tell you right away, because the liability beyond the statement plus 60 is the customer's liability. So the longer they wait to tell you, the more liability they take on. If they tell you right away, they might not take on any liability because we got to the bank and the bank shut it off in the first 2 months or something like that. The problem with that general liability is it's not absolute. You might say, well, what's that mean? I'll go back to what I made sure I clarified with Diane. We had several different types of transactions that were unauthorized. The question for the bank is, do you know that the theft is all the same theft? And you might say again, well, what do you mean? Well, I think we would be naive to think that our information hasn't already been stolen. It's not a matter of if, it's when. Cards get compromised all the time. Bank account information's compromised all the time. It just may not have happened to you yet, but it's probably already been stolen, just hasn't been used. So if we're going to go back and say these, let's just say there's 5 of these different transactions that are unauthorized. If we can verify that they're all part of the same theft, then I can buy into the statement plus 60. But you better know for sure. Otherwise, each one of those would be its own statement plus 60 time frame. So somebody stole my credentials and they're using them on Venmo. Somebody else stole them and used them on Cash App. And yet somebody else has stolen them and using, somewhere else. Each one of those incidents might be its own statement plus 60, or maybe they're all part of the same theft by the same person. Regulation E is gray in that area to a certain extent, but remember, it's a very consumer-friendly regulation meant to protect the consumer, not necessarily the bank. So to go back to the answer, we might be able to apply statement plus 60. We might not. It depends on the facts and circumstances, more so than what was provided within our scenario here today.
When talking about Regulation E, could you expand on Venmo, PayPal, Cash App being defined as financial institutions and exactly whose responsibility it is to do what when it comes to error resolution?
So those Q&As that came out in December were extremely important on that side of the equation. Okay, not the bank side. As a bank, we knew we might be liable for some of these transfers. Now, it did clarify some things for us. But on the third-party side of the issue, those Q&As, matter of fact, state that they're on the hook, Cash App, Venmo, PayPal. And so if the customer goes to them, then they have to deal with Reg E, just like you have to deal with Reg E. They have timeframes. They have provisional credit requirements. They need to make the customer whole. If the customer comes to you, the Q&As also clarify that you need to do the same thing. There is a very small loophole, and I don't know it off the top of my head, but I can tell you that it exists. There's a very small loophole in Reg E that says for certain P2P transactions, or it doesn't use the word P2P, but third-party transactions like this, if certain criteria are met, you might be able to pass the buck solely onto the third party. But I can tell you it's few and far between, and it's only ever going to apply to certain ACH transactions, when will never apply when the transaction is a debit card transaction. And you might say, well, how will we know? Well, we've researched this. We've gone and looked at bank accounts. You'll be able to see the type of transaction that the bank conducted through the third-party app in order to carry out the transaction. Most of the time, they're debit card transactions, which means you're going to have to pick up the dispute and follow Reg E if the dispute comes to you first, rather than going to Zelle, Cash App, PayPal, etc.
When you have an organization, such as a local fire department, opening an account, what is the best way to determine if they're a political subdivision?
I would say you'd want to get something about their makeup, I suppose articles of incorporation, their papers, explaining who they are and how they operate. It would be my guess.
What are your thoughts on specific accounts for employees with perks? If an account is created with perks, should it be open to everyone, not just employees?
I don't know that there's anything that prohibits from the financial institution from having employee only accounts on the deposit side.
Would we also have to consider Regulation DD and any IRS reporting if perks or bonuses are provided on employee accounts?
Yeah, just because it's an employee account does not get you out of IRS requirements. In fact, because it's an employee, there are more IRS requirements that you would have to comply with. So yes, you would have to comply just the same.
We currently mail out quarterly interest notices on certificates of deposit. Since not required by regulation, can we just stop mailing them out, or do we need to provide a notice?
Since it's not a regulatory requirement, what I would do is look to what you originally told them in the first place by way of your contract.
If a customer is only receiving digital statements, are we required to notify them when the statement is available?
Not to my knowledge, under any of the regulations like Reg DD. There may be something in e-sign, but we're not e-sign experts.
We recently became aware that several of our customers were indicted for fraud and some arrested. Can we close these accounts simply because of their prior legal issues?
Absolutely. I mean, again, you'll want to look to what your contract says. It probably has something like closure for at will or something like that. I don't know anything that would prohibit you from closing the account for character issues. The two banks I work for, we did that not often, but occasionally.
Currently, we use our card processor to perform investigations for card disputes. What other methods of investigation are institutions using? If a notification of a potentially unauthorized transaction is received years later, which would be rejected by our processor as outside of their timeline, how would this be expected to be resolved?
Well, let's tackle the first part of that. So just generally, what other than our merchant processor, what other ways could we do investigations? You could go to merchants directly. You could seek out information from them, whether it's a brick and mortar merchant or somebody that's online. You could conduct an analysis of your own internal history with respect to the customer. So there's lots of different ways you can do the investigation without outsourcing it to a third party. Now, let's talk about the rest of what was in that question. When you go through these processors, oftentimes they have a time limit that they say we won't investigate it if it's beyond 60 days or 90 days or whatever it is for that processor. So what's that mean? Does that mean that the customer doesn't have a legitimate dispute because it's outside of your processor's time frame? No, it's still a legitimate dispute and still one that you are required to investigate. You're just not going to get investigation help from that third party because they're going to tell you it's outside of their parameters. And that means you won't get your money back, but it doesn't necessarily mean the customer doesn't get their money back. So it means the investigation is solely on you then at that point. So maybe you do have to reach out to the merchant. Maybe you need to go online and do your own investigation of what they're disputing. Maybe you can find out they didn't read the fine print. Okay, and find out what the website they use, what exactly they did, how it works, and make your own conclusion. But it doesn't just because it's outside of those timeframes, it doesn't mean that you don't have to do an investigation to determine whether or not it's truly an unauthorized transaction.
What are your thoughts on using e-sign for outgoing wires? And is it okay to have a wire transfer form signed by e-sign?
So to my knowledge, e-sign is not required for outgoing wires. And I think what they're really asking is, can we rely on an electronic signature as opposed to an in-person, pen signature, if you will? I can tell you, we've had some consultation with some banks on this issue. Electronic signatures are the new way, if you will, because most things aren't happening in person anymore yet. And it likely doesn't go back to that. You're going to need to come up with your own internal protocol procedures on how you want to handle that. It's really a matter of what you feel comfortable with and what's legal in the first place.
On debit card applications, if a minor over the age of 13 is issued a debit card, should the application be required to be completed with the parent's signature?
It's really a legal thing. They're not a compliance thing that I can give an opinion on. I can tell you, I just opened up a debit card for my two teenage children, and I had to sign. So it seems like that's probably pretty normal.
On online accounts, do you need to have a form completed when you commingle business and consumer purpose accounts?
Well, let me start with the last part of that, and I'll probably finish there too. I would not commingle personal and commercial accounts. That you get into some bad situations when that happens. I would make sure that we strive to keep those separate. Think about it this way. I've opened up a consumer account with you, and I'm going to run my business transactions through it. Guess what? Those business transactions now get Reg E coverage. Not something you want, as Reg E is becoming even more consumer friendly than ever before, and we have a lot more fraud and unauthorized activity going on. So I would make sure you keep them separate. When you identify an account that was supposed to be a consumer account and they're running commercial transactions through it, I would have a discussion with that customer and make them set up a separate account that doesn't get the same protections as the consumer account does.
Can you explain how Regulation E errors work under programs like Zelle? Specifically, do the rules differ if they use our app or the Zelle standalone app?
So this is kind of a similar question with a similar answer to what we've had a couple of times already. So if you're offering Zelle through your financial institution so they can conduct Zelle transactions, those are going to be your issue. So Zelle transactions are going to be your responsibility. Now, if they go to Zelle first and don't come and see you and Zelle takes care of them, great. If they go to Zelle and you need to pick it up as well. So though that's what those Q&As from December of 2021 addressed, that you can't just say not mine because there's a third-party app involved.
Are regulators scrutinizing disclosure language regarding Nsf fees on represented items? And do you have any recommended language that covers charging per item and per presentment?
Yes, they are. In fact, our team today, I've had two different discussions with two different teammates. Diane was one of them, and some of you know Amy Kudlachik. I had a discussion with her about this earlier this morning. The FDIC and other regulatory agencies, the CFPB as well, in the last probably 6 months, there's been a ton written on this. It's not just a regulator thing either, by the way. There are class action lawsuits out there, and there are attorneys that are looking to chase these down. So if they find out that your bank is doing this, okay, there are attorneys out there looking to identify you and then go public with this so they can get class action lawsuits put together on your financial institution. And what we're finding through our research is that I don't know a financial institution yet that hasn't settled as it relates to this issue. Now, what's the issue? For those of you that maybe don't know, if you have an Nsf fee, which I'm gathering most of you do you charge an Nsf fee each time the same item is presented multiple times? So I bring a check in I write a check and it gets returned NSF. And so there's an NSF charge, but then it goes back to the merchant and the merchant tries to present it again a second time. If you charge each time a single item is presented multiple times, okay, it's not that you can't do that. It's did you clearly disclose that to the customer? Well, what we're finding is that most financial institutions have not described it at all anywhere. Those that have, where is it found? In the account terms and conditions. That legal agreement, the long paperwork that comes with the account, it's buried in there. You have to be careful though. Sometimes if it is buried in there, you need to make certain, does it match up with what the fee schedule states? Sometimes we've seen the correct language based on what the bank's doing in the account terms and conditions, but then we go to the fee schedule and it says Nsf fee per item. Well, that does not give any indication that it's going to be for each time a single item is presented multiple times. So you need to find out, what does your legal agreement say? What does your fee schedule say? And then what are we really doing? And then reconcile it all. We've seen that banks have had to do restitution on this, either by way of pressure from examiners or by way of class action lawsuits. Either way, the bank's losing, regardless of how it's brought to the bank's attention by a third party. Now, if you're able to catch it yourself and fix it before the examiners get in, you might be able to skate freely through your next examination. But if you have an issue here, it's not a matter of if, it's when you're going to have to deal with it, especially through an exam.
And right along those lines, we have someone asking if we think regulators will go as far as telling banks they can't charge for representments.
I have not heard that one yet, that they cannot charge. Now, if you did not adequately disclose it, then you might get told, I'm sorry, you can't do this because you haven't adequately disclosed it. You should be able to disclose it, accurately represent what's going on, and then charge that fee. I haven't heard anybody that's been told no, they cannot.
Under Regulation E, if our investigation does not find any evidence that a disputed transaction was authorized, and we give notice that provisional credit is now final, but later receive evidence that the customer did in fact authorize the transaction, are we able to go back to the customer and reverse the provisional credit that we've made final?
Oh, I want to say a couple years back, the Federal Reserve and the other agencies did an Outlook Live publication, which is a free webinar that's put on periodically by the regulatory agencies through the Federal Reserve's website, if you will. And I want to say one of the things that they included in there is once you've made it final, you don't get to go back and reopen it. Now, I can tell you, we had some internal discussions that we do not completely see eye to eye with that. At the end of the day, that's where the regulators landed, whether we like it or not. Now, you could take your chances and go get the money back. And if you feel firmly that you're in the right and they're in the wrong, and take your chances with the examiner, and maybe they don't ever find out about it, you can choose to do that. But the guidance from the examiners, and this isn't regulatory as far as regulation, this is just guidance, is that once you've indicated that's final, it is final, and you're not to go taking money back or reopening.
And kind of a follow-up or a second part to that question, would it matter if we were still within the investigation timeline or not?
It would if the customer closed it and wanted to reopen it. It doesn't, there's nothing that I'm aware of in the regulation that if you've closed it, that you get to reopen it.
For Reg E disputes, what are some good methods for confirming a customer benefited from the product received? For example, could we rely on a delivery address?
I think that the whole idea of, so the definition of an unauthorized transfer is that it is not conducted by the consumer and the consumer did not receive any benefit. I think the argument that the consumer did not receive any benefit is a weak one. And I don't have any examples. Do you have any examples where you think somebody would have a leg to stand on that? I think I'd have to have more facts and circumstances relative to the scenario.
Yeah.
I don't know if I can just go delivery.
Since Reg CC doesn't apply to savings accounts, should we not provide a hold notice for those accounts?
Well, one of the things that we have a model form that we allow financial institutions to use. And one of the things that we have made available on our form is, and I think it's the upper left-hand corner, it has a checkbox for demand account and savings account. Why is that? Well, it's for exactly the reason this question has been asked. If I'm the compliance in the bank, I want to have a vehicle that is the same for placing a delay on deposits into a demand account as a savings account. That makes it easy for my team when they want to place a delay on a deposit. Oh, here's the form. And then they just check the appropriate box. And then the person who's storing or scanning those delay notices, they know that it goes into this bucket if it's demand account and this bucket if it's a savings. Why? Because I'm only ever going to hand over the demand ones to the examiners and the auditors. The savings ones are for my eyes only because they're not subject to regulation CC. So I would use the exact same notice, the exact same procedures. I would just file them in two different buckets.
Does a business have to have a business debit card for Regulation E not to apply?
I don't know what the label on the debit card matters. What matters is when you open up the account, did you provide them Reg E protections by way of your electronic funds transfer disclosure? That to me is the big thing.
Can you provide any further guidance on what it means to take for collection that was mentioned in for purposes?
Sure. So there's a process, and it's been a long time, so I don't know it off the top of my head, but I'm sure you can go out and Google it, where you can place a check through the system for collection as opposed to accepting it for deposit. There is a fee that's tied to that, to my recollection. Beyond that, I'd have to go research it just like you would.
If we change our fee schedule to reflect updated language, but no change to a fee, do we need to let our customers know? And if yes, how soon after the change?
So couple different regulations on the line here. We've got Reg DD, we've got Reg E, Reg CC, funds availability. And am I leaving anything out? Looking to Diane. No. Okay. So then what we're going to look at is, all right, is if it's adverse to the customer, there are timeframes that are established in these three regulations. So 30 days, 21 days for Reg E. And so if it's not adverse, we still have to provide an update. Like in Reg CC, I think you get until 30 days after for things that aren't adverse to the customer. So it just depends on exactly what you're doing and what regulations are covered.
Is a 9-day hold still an option for regulation CC holds?
Well, there's 7 days for the reason that I have a reason. And then there's the 2-day. And then I know there's some other special circumstances. I don't know them off the top of my head. Do you know, Diane, is there one of them that's 9-day?
I want to say new accounts if you disclose
Accounts?
that.
Okay. Yeah, off the top of my head, I don't know any more than what I was able to share there.
Jack Henry has a new BANO system that allows a customer to tag a particular transaction and question the charge or dispute it as unauthorized. The bank requires written confirmation of Reg E error claims, and this person is wondering, would a written notification through Jack Henry's BANO system be considered a written claim, or can we still require them to complete our statement?
Well, I'm sorry to be the bearer of bad news here, but underneath Regulation E, you cannot require them to put it in writing. So you need to, once you're notified orally or in writing, okay, either I get to bring it to you anyway, you need to conduct an investigation, either under 1005.6 or 1005.11. Both sections in Reg E, an oral notice is all that's necessary. You cannot require anything over and above that in order to start an investigation. So make sure you fix that part first. Now, under 1005.11, if they want provisional credit, walking around money, if you will, then you can ask them to put it in writing. And if they don't, you don't have to give them provisional credit, but you still have to conduct the investigation. So you're going to want to examine that whole in writing thing. And I do believe that if they have flagged through Jack Henry, through like your mobile app or something, that something is unauthorized, you're now on notice.
Can we reopen a closed account to charge back a check, creating an overdraft that will then be collected upon?
That sounds bad, first off. Number two, this is going to be a legal thing that goes beyond what I'll say is the typical compliance regulations. I know that both the banks I worked at, one of the first rules I ever learned was we will never reopen accounts that have been closed. And number two, we'll never just take somebody off an account. If somebody wants an account without somebody else on it, we open up a different account.
On the Nsf Fee issue regarding representments, we do have a few people saying that they don't know how they can identify these, but also some questions on, we're stating per item on our fee schedule, and they're wondering, should we change it to say per presentment? And there's a lot of questions just asking for recommended language. What do we use? So
let's break that down. The first part of that, and you may have to remind, what was the first part of what you just said there? I was trying to remember it.
We just have some people saying they're having issues identifying these.
Okay, let me go there. I can tell you, we've talked to some clients as well, especially ones that have been told they have a problem and they have to go provide restitution, and they start looking, they're going, how do I identify these? So I have heard that that's a problem, Diane. I know you and you've talked to some people as well, that yes, I just want to chime in and say, we've heard that there's some issues in trying to identify what these are in the past. So yes. The second part, let's talk about the language. If you say per item on your truth and savings schedule, then that's one time for being able to charge that fee on that particular item. If it's presented another time, you don't get to charge again based on the label per item. So again, Diane and I, we were just talking about this morning. What is some good language? So we got to get rid of that per item thing. We're going to list out, non-sufficient funds fee or Nsf fee, $25. And then underneath that, in parentheses or in some kind of description, each time a single item is presented, or maybe it's each time. You said something this morning, Diane. What was that? Would you mind sharing that? What we were talking about?
I think I mentioned just putting like under the fee, a single item can incur multiple fees if presented multiple times.
There you go. There you go. Something like that. I can tell you, I've got our, I don't know where I put it here, but we're having a team meeting on Monday, our bankers compliance consulting team, and we've added this to our agenda. And we're going to chew on this language. And I tell you what, Diane, maybe we can put this in some notes somewhere. Maybe we can put something out to everyone. As you know, here's kind of the language we landed on this, and share it with everybody. That's one of the things we do. So we'll follow up on that one with everybody, either by way of our blog, or maybe it's a follow-up to everyone who's registered for this program today, and get you what we decided to land on Monday. And then it's going to come with this caveat. That's our recommendation. You're going to have to run it through your system. Make sure you do what you say what you do, and just make sure that you're saying what you do in one place versus what you're doing in the other place. So disclosures versus the system.
With respect to Reg D, excessive transactions for savings and money market accounts, has everyone stopped monitoring since it is no longer part of the regulatory requirements? And if so, should our truth in savings disclosure remove the language altogether? Or can the disclosure state may be limited and still allow us to charge for more than 6?
Well, the last part of that question is really how I was going to answer it. I wouldn't say every institution has just eliminated the language and the limitations, because the federal requirement is gone, but you can still limit transactions on accounts. It has to be clearly disclosed, just like it always has. So if you want to do away with the limitations, go for it. There's actually no regulatory requirement for you to follow up with the customer. Now, we do think it's a good customer service benefit for you to do so. If you did away with them and you're going, gosh, we'd really like to have those back, well, then that's an adverse thing under truth in savings. You'd have to disclose that 30 days in advance. So I wouldn't say everyone's done away with it. There's some that kept it, some that decided to keep it, and now are thinking, gosh, we're just going to get rid of it because it's not worth the hassle. So if you've kept the limitation, then it makes sense you would continue to monitor the excessive transactions. If you've done away with the limitation, you're wasting your time and resources with any sort of monitoring there.
Can you confirm that we are not required to provide a truth in savings disclosure to a business account and for the purpose of the business? And this individual says they were recently cited for not including the compounding frequency on a truth in savings disclosure for a business purpose account.
So I'm drawing a blank here, but truth in savings only for consumer accounts, right?
Yeah.
Yeah, I'm second guessing myself just because of the way the question was worded. I'm like, maybe I've forgotten more than I remember at this point. But yeah, I would say consumer only.
Can you please define the statement plus 60 time period for Regulation E? My understanding has always been it is 60 days prior to the last date the statement was cut.
So the bank, when somebody says this is unauthorized or a disputed transaction, the total liability for the bank under Reg E is supposed to be the statement on which the error first occurs, plus the next 60 days. Beyond that is the consumer's liability. So that's the statement plus 60 item that I was describing earlier on. Now, the misconception is that bankers out there believe that the customer has to tell the bank within 60 days of the statement being sent. That's not true. Okay. If the customer tells the bank about an item that's being disputed within 60 days of the statement being cut, then the bank has to follow 1005.11 in Regulation E, which is provisional credit, the walking around money thing, and then you're on a timeline to conduct and complete the investigation. If the customer doesn't tell you within 60 days, it's still a dispute, still an unauthorized transaction. You just follow 1005.6, and under 1005.6, there's no walking around money, provisional credit, if you will, and there's no timeline that you have to follow. You just have to investigate and then make it right based on the results of your investigation. So that's probably the most misunderstood part of Regulation E, is the whole 60-day thing and how it works. Statement plus 60 is your liability. The customer is told to tell you within 60 days to limit their liability, and then there's a 60-day correlation to 1005.11. But if it's not followed, you have to follow 1005.6. I wish I knew cooler things. I tell my wife that all the time.
I think that's pretty cool. So
next question.
This next one is referencing article in our May magazine that
Okay.
cited violations from the CFPB that institutions were not providing a written explanation of their findings when they're saying that no error occurred. And this individual is wondering if we add a statement for the consumer to contact the bank for additional information and give our phone number, do you feel this is adequate?
So this is when we've completed the investigation. It's different than what they thought, or we're taking the money back.
Yeah. Yep.
That's the sole written requirement in Reg E, that you have to communicate with the customer. So you have to make that written communication. If you're trying to circumvent that, there's no way in my mind that you can do that. You have to provide that written follow-up.
Is a mobile device considered an access device? And if a consumer loses their phone and transactions occur through Venmo or Zelle, is the consumer required to notify us to limit their liability?
So let me do this. If my phone's lost and somebody steals money out of my account electronically, it's covered. Is it an access device? Gosh, I'm trying to think of off the top of my head, what's the exact definition of an access device? And I don't have it off the top of my head. Do you have thoughts on that one?
Well, since you mentioned the definition, is that a card or a code? So,
Well,
but
that's the part I was missing. There you go. So it's my login and my password. So don't think of access device, and I don't have a one around here, but as just the card. It could be the account information and the log and the password, or the login and the password. And so like on my phone, I don't even have that with me, but if I had my phone here, I can tell you that I'm logged into most everything constantly. Now, some of the stuff I have now has facial recognition or whatever. And so I'm not logged in unless my face is there. So hopefully they can't get into it. But let's assume that I lose my phone and it's automatically logged into these things. That's an access device because of the login and password credentials being utilized to conduct transactions. So yes, that's exactly what I was looking for, Diane. Thank you. She's the brains behind all this. She makes me look way better than I really am.
you're also a liar, but okay. Does a check have to be above a specific dollar amount when depositing into a checking account and placing a Reg CC hold?
No, actually, the case by case delays, you're going to make the first $200, $225 available based on your general availability schedule. There's the large deposit, which is 5,525, right, Diane? They changed those numbers on me. So. Anyway, there are different dollar amounts for certain things. And then like on the overdrawn one, there's a dollar amount tied to being able to use it. But no, there's not a certain dollar amount other than a large deposit.
We currently mail our CD interest and maturity notices. Is there anything that would prohibit us from moving these to an e-notice?
Other than e-sign, we'd have to look at truth and savings, and I would imagine that that's covered by e-sign. The general rule of thumb on e-sign with disclosures, and there's some exceptions, is if it's a disclosure required by the regulation or a notification required by the regulation that is leaving the bank and going to the consumer, it's got to go in an e-sign compliant channel, meaning I can't just email it. It's got to be e-sign compliant, meaning that there was a consent with the customer that they want to communicate electronically, and they have acknowledged, step 2, that they can see or view the format in which you're sending it.
Should daily bill pay and P2P limits be disclosed in our Reg E disclosure? We have them disclosed in a separate agreement and an online mobile banking screens. Is that sufficient?
Oh, I want to say we've been down this road before. Diane, do you recall? I don't.
I think it needs to be disclosed somewhere.
Yep,
so if they get it, at account opening and they have the service, then that should be good. Otherwise you get into, is it, a reasonable time within when they signed up for the service. So.
Yeah. And then like even mobile. Yeah. I'm just going to leave it there because I don't know off the top of my head.
With a Reg E dispute, we need to start our investigation based on oral notification, but we don't have to give provisional credit if we don't get it in writing. Can you confirm this is true?
Yeah, so under 1005.11 in Regulation E, once you're notified of an unauthorized transfer or dispute, the investigation it's required to start. You can then ask them to put it in writing in order to give them provisional credit. And if they don't put it in writing, then you don't have to give them provisional credit. Reg E's time frame for provisional credit is 10 days. So you can say, hey, Diane, thanks. We'll get right on that. If you would like walking around money while we do our investigation, then we need you to put it in writing. And we need that by the end of 10 days. If Diane doesn't get it to me within 10 days, I still have to complete the investigation, but Diane doesn't get the walking around money. Careful, some of you that have Visa branded cards. Visa has a 5-day provisional credit rule, and you cannot require written confirmation any earlier than 10 days. So under Visa transactions, you're very likely going to give them provisional credit no matter what at day 5, because Visa says you have to, but you can't require them to put anything in writing any sooner than day 10, which means it's kind of a moot issue, right? You'll have to give them provisional credit on day 5, regardless of whether or not they've put anything in writing, because you can't require it any sooner than day 10. That's something that many financial institutions have overlooked. We don't see it get written up in exams, but you have overstepped if you're doing that.
Back to the whole Nsf fees on represented items. What if the suggested language is already in the account agreement, but the fee schedule does not state per item?
So if our legal agreement is okay, fine. Now we need to do an update on our fee schedule. The fee schedule is tied to Reg DD, Truth in Savings, and you're now going to charge them more than what you were charging before. And you're going, wait a minute, no, we're not. We've been doing it, the agreement, right? But you still got to follow Reg DD. And so you've got to do a 30-day advance notice. Now that doesn't get you out of hot water. That fixes it going forward. We still have the issue looking backward. Now, if you're doing this outside of a regulatory examination, maybe we'll get lucky and they won't notice. But you know as well as I do that one of the things they ask ahead of every examination is any change in terms since the last examination. And so if you're trying to pull one over on them, it probably isn't going to work. Now, I wouldn't go and do voluntary restitution. I would do the change in terms 30 days out and wait for the examiners to tell me I have to go back and do restitution on this. But I would prepare my management and say, all right, here's our plan. Our legal agreement's good. We've got to change our truth and savings disclosure. We've got to send a 30-day heads up. Then we'll be in line. We need to make sure that we do the numbers on the backside of this in case our next exam, our examiners tell us we have to do restitution. We might skate through though, but we should be prepared in either way.
Okay, on a debit card transaction, if a customer has good funds on the pre-authorization, then when it hard posts, it causes the balance to go negative. Can we charge an Nsf fee?
Maybe. My first question is going to be, are you an opt-in bank? If you are not an opt-in bank, never will you be able to charge in that case. If you are an opt-in bank, it depends on what you've disclosed in your account terms and conditions in describing that this can actually happen. And it's tricky. I've seen some account disclosures that have tried to do this and they do a pretty good job. I've seen some that have completely missed the mark. Then you have to make sure it's somebody that has opted in. So opt-in banks that don't have an opt-in, never. Banks that do provide an opt-in, the only way you could ever legally charge this, I shouldn't say legally, under the regulatory requirements, is if the customer actually opted in to be charged. And then you would have had to adequately disclose it as well. And you might say, well, gosh, we give the model opt-in form. Well, then you need to be familiar. There are at least 2 court cases in the last couple of years where the consumer has brought a lawsuit against the financial institution because they didn't believe they were fully informed by way of the model disclosure. The bank argued, we use the model disclosure, we're supposed to get a safe harbor, right? The court said, not so much. And these court cases have not completely played out yet, but it looks like there are some chinks in that armor that is the safe harbor for the opt-in. those opt-in forms need a makeover. The CFPB a few years back tried to roll out some updated versions in a prototype fashion, and they fell off the side of a cliff and have not been seen since. We do expect the CFPB, the new leadership group, at some point to address some of this Reg E stuff as part of the ongoing overdraft reform. So we want to be careful what we ask for, but I do think we're going to get some updates there down the road. Did I go back and answer the original question? I kind of got off in a rabbit hole there.
I think so.
Okay. We got time for probably one more, and holy cow, that hour has flown by.
Okay, so this is the bonus round. Customer has their own PC compromised. The culprit uses the saved credentials to enter the customer's internet banking and adds a bill payee and sends off funds to them as a bill pay. Is this a Reg E event?
Absolutely. Absolutely it is. No
right.
question. Well, I tell you what, folks, we're just about 2 minutes out here before the top of the hour, according to my clock here. I've got a couple things I want to do here in closing out. First off, I want to thank Diane. That was a rapid fire round of questions, and I even appreciate you chiming in on a few of those hard ones there. Appreciate all the work and effort you did to moderate and bring as many questions in some plain English to the lives of those that chimed in today. We had a record crowd today. We had almost 1,000 people registered, and I don't know what the number live got up to, but I know it was over 600 at one point. That is so awesome today. Hopefully you found some real value in the questions that we all shared with all of you here today. I'm going to share my screen one more time here, and I've got a couple things I want to do here as we close out the program today. So stay with me just a moment. I promise this won't take a ton of time here. I want to mention the next round of our compliance forum. The next one is going to be a Bsa Aml version. So in January, the first quarter, we did our lending. Today was the deposit and operations. The next one is the Bank Secrecy Act anti-money laundering version. We'll be doing that on July 19th. You can get registered. That link's out there. It's part of the materials today, and reserve your seat. We climbed almost to 1,000 people in this last registration. So you want to get in and make sure you've got a seat for that next version. The fourth one, the one that will be coming up in the fourth quarter this year, that is probably the most popular one. That's the look back and what lies ahead. It's like a giant compliance checklist for the year to make sure that something didn't slide by and you or your teammates miss it along the way. Also, just a reminder too, that if you're looking for compliance training a little bit later this fall, our virtual compliance conference series, that's out there. You can go and get registered for that. One ticket gets your whole team trained. With that, I have that it's exactly the top of the hour here today. So we're going to do our final closeout today. On behalf of the entire team here, I want to thank you for stopping by for some compliance Q&A of the deposit operations variety. There is a short survey that popped up behind the scenes here today. 5 short questions, always looking to move from good to great. It'll take you less than a minute. Give us a little feedback on the program. As to the recording, I know that some of you are going to want to go back and listen to this and share it with other team members along the way. Listen to what they say here to the answer to this question or that question, whatever it is. We'll let you know. You'll get notified when that recording is available, and then you can go and share that with all the people that you think would benefit from that. With that, we're now going to let you get back to what it is that you all do so well, and that's serving your customers. Thank you again.